special show on the very critical issue of child pornography and how India is dealing with this evil. I'm Gargi Rawat. Worryingly, there has been a staggering increase in the number of recorded cases of child pornography. If we show you the statistics, according to the National Crime Records Bureau, it's gone up from 44 cases in 2018 to 1,171 cases in 2022. The sexual exploitation and abuse of children was brought into focus last month when the Supreme Court issued a landmark judgment that makes downloading, storing, possessing and watching child pornography an offence under the POCSO Act. Not just creating but also downloading and consuming such exploitative material is the starting point for a child's victimization. It lays the grounds for their exploitation in many other forms. And one of the platforms for this exploitation is the online space, which is inhabited by predators who use cyberspace for the abuse of children. Today on this show, we'll look at the judgment, what it says and what long-lasting impact it will have in reducing online child sexual abuse, as well as hopefully eventually ending it. Joining us to discuss this on the show is Bhuwan Ribhu, a prominent child rights activist, advocate, author of the book When Children Have Children, Tipping Point to End Child Marriage. He's also the founder of Just Rights for Children Alliance and petitioner in the Supreme Court of India's landmark judgment on child sexual exploitative and abuse material. Thank you so much for joining us today on this very, very important topic, a topic that people need to know more about. People need to understand how serious a crime it is and how, just by watching something, how they're actually encouraging it. So first and foremost, if you can, for our viewers, explain this judgment, what it means, and how does this strengthen India's framework to, fight these kind of evils of child pornography?
First and foremost, India is now at the forefront of the legal as well as the institutional framework for the protection of children, especially in the online space. On one side, the Supreme Court of India has done away with intent, that it is no longer important to look at the intent as long as you are committing the crime of a sexual nature against a child. Secondly, the Supreme Court has allowed a civil society organization, in this case the Just Rights for Children, to actually petition the court in a criminal matter. It was a criminal justice issue and the Supreme Court of India has done away with it. Secondly, the Supreme Court has created the institutional framework mandating that the intermediaries who are getting to know of such material are now duty bound to report it within the Indian laws. They have to report it to the police in India, which is a paradigm shift. So not only have they criminalized this CSEAM, they have not only done away with intent, they have also made intermediaries accountable, which means that now you and I can report and the intermediaries and the police are duty bound to follow. This actually provides the umbrella of protection to all children, because the threat of online abuse is for every child who is today using any social media platform, who is using the computer and the online space in any manner, fashion.
That's right, and people must understand that, it's not just that if you're partaking, you're guilty. It's also if you're watching, downloading, as you emphasized there, which is what the Supreme Court has now, in this framework brought in. You spoke about the Madras High Court judgment. If you could just, tell us more about how you went to the Supreme Court. Obviously, everybody was outraged with that judgment. I cannot imagine how a judge in this day and age came up with that. But yes, tell us about how you decided to go to the Supreme Court. As you said, it was a criminal case, but yet they allowed you to petition.
Law is nothing but a piece of paper unless and until it is enforced. And it is the law which is going to create the notion of what is right and what is wrong, what is allowed and what is not. If we are looking at law with a myopic lens where we are only taking one section of the law and not only looking at the law in its entirety, India has a very robust law against CSEAM and child sexual abuse material. That law was not looked at in its entirety. This man was searching for child pornographic material actively. He was identified by international agencies. This information was shared with the government of India. The government of India shared this information and intelligence, which was very actionable and precise, with the Tamil Nadu police. The Tamil Nadu police actually tracked the IP address and went and arrested this man. On his mobile phone, such videos were found, and he said, because there is a technicality in one section of law that says that my intention should be to circulate or to sell, the High Court in its wisdom actually looked at only those two sections of the law and did not look at the IT Act. So section 15(1) of the POCSO says storing is a crime. Section 15(2) of POCSO says storing and circulating is a crime. Section 15(3) says storing, circulating and selling is a crime with different degrees of punishment. So the Honorable High Court had exonerated this man and quashed the FIR against him in section 15(2) and did not even look at section 15(1). In this particular case, the Honorable Supreme Court allowed us a bunch of civil society organizations who came together to approach the Supreme Court. And in this particular case, a special leave petition was filed by over 175 organizations that came together under the banner of Just Rights for Children Alliance and approached the Supreme Court saying that this is an affront to society. It is an indignation to us all. If we are failing to protect the children and allowing such crimes to take place, if we are allowing the demand for child rape to perpetuate in this manner, and if we are allowing people to pay for this child rape, no matter where it happens in the world, a child is a child and must be protected. And therefore, the law must come to the aid of such children and ensure that these people are not allowed to walk on the streets like that. Thankfully, not only the Supreme Court took up this case within record time, but within 6 months, this landmark judgment, the first of its kind judgment, came in this short period of 6 months, with such elaborate guidelines.
Yes,
very extensive judgment. Yes.
It's good of the Supreme Court. And I just want you to go back to the point that you were making about, when you say what's in name, when you said the Supreme Court has made this distinction between child pornography and now calling it child sexual exploitative abuse material, or CSEAM. If you could just, for our viewers, why this distinction is so important.
Fundamentally, pornography is seen as an adult indulgence, as I was saying. This is not a private affair. This is where you are creating the demand for a child to be exploited, abused and raped. And the rape of the child may be one crime that happens in one corner of the world at one point in time. But the perpetual circulation of that video will be there in eternity. What this crime is doing is that it is exploiting the child and creating a culture of fear, a culture of embarrassment, a culture of shame, a culture of living in this stress for the family, for the child forever, because you do not know when this video is going to crop up. It is there. That culture needs to be seen in with the lens of the crime and must be taken down. And that is where the Supreme Court has made the intermediaries accountable. And that is what it does.
To talk more about that, the impact of this judgment on tech companies, what is that going to be? You said intermediaries, the Supreme Court, defining that. And as we said, it's a very, vast judgment that they've given, going into many aspects, sex education as well. But yes, in this day and age of tech and children, being on social media, etc., and, vulnerable to tech companies, what is their role now? What is their responsibility now?
Currently, as the system of reporting stands, every company that is doing business in India must report, as per this judgment, any such abusive material CSEAM to the local police. Earlier, they were reporting to an organization based out of United States because they were not mandated to report it in India. Now, in the US, they would report. That organization will share that intelligence with the Indian authorities. Ministry of Home Affairs. The Ministry of Home Affairs is going to share that with the local police. It's a big circle. You are doing business in India. You are earning your profits in India. The crime is happening in India. You are identifying the criminal in India and you are reporting it to a person sitting in the United States. That cannot be allowed. If you are here, then you have the infrastructure to report. You have the wherewithal to report. You have it was just a question of will. and that has been mandated now by the Supreme Court. You are supposed to report it. This is a borderless crime, but if a person is sitting in India and doing this crime, then it is the Indian law that is going to take action. Also and simultaneously, no child is safe from this crime. Any child, regardless of age, if the child is online and if they are on social media, they do not know who's sitting on the other side, who's chatting with them. Yes. Predators are pretending to be children. Predators are pretending to be girls. Predators are sharing and encouraging, enticing, deceiving children to send their own sexually explicit photographs and videos. That kind of self-generated imagery is being done. Children are being blackmailed, harassed, threatened, bullied by using artificial intelligence mechanisms. All that this Supreme Court judgment really caters to and ensures.
Clearly there's a need for society to be more aware about all this. As you said, this is a new judgment and it's very complex, very vast. Well, we'll continue this discussion and, lots for clearly society at large to learn, as police as well. We're going to slip into a short break. On the other side, we're going to take a look at what parents need to do. How can they educate themselves better in this day and age of, digital and social media and so many dangers out there. Stay with us. Welcome back to our special show on ending child abuse online, and we're talking about the recent Supreme Court judgment that extensively laid out the law to combat this evil. Now, with us in studio, we have Bhuwan Ribhu, who's taking us through all these different facets of the Supreme Court judgment, as well as what we can do. Now, if we talk about families, I'm sure there are a lot of parents out there who are very concerned about what can they do? How can they educate themselves better? How can they, ensure that their children are aware? Also schools, what can schools do? And let's not just talk about cities. What about rural India, Anganwadi workers? They also need to be sensitized and educated about this. So if you can tell us, what needs to be done now at a, societal level?
First and foremost, children need to be educated. They need to be also told about the perils that are lurking online. They need to be made aware of the social media facets and many times the deception, the enticement, the predatory behavior, which is all online. Also on the gaming companies, a lot of times people are using the gaming websites to actually identify and exploit children. So all these may be the responsibility of parents and schools on one side. On the other, when a child is actually coming to you, trust the child. When the child is coming and asking a question, then maybe look beneath the surface. If the child is suddenly withdrawing, if the child is quiet, if the child is in a sort of a sadness or depression, then there must be a reason behind it. Look beneath the surface and maybe you can see what is going wrong. Then report. Whenever such a thing is happening, it is not the shame or the embarrassment of the child. If somebody is enticing the child, it must be reported. If such a photo or a video or something is in circulation, then immediately the companies that are actually doing business in India, they have to take this down and they have to be informed or told. The police must register a case and the police must act promptly. These are not crimes that are that can be allowed to go on in perpetuity. While the Supreme Court of India in this particular instance took only 6 months to come up with a landmark judgment, the case is from 2019. So
yes,
that
it's been going on and on.
Exactly. Yes. So POCSO Act mandates all such cases to be tried and finished within a year. And these are cases of child rape and they have to be seen as such.
And even the forwards that you may receive if you get on WhatsApp, one has seen, in UP, Bihar, these rape videos have become very popular on WhatsApp.
Also, people who are buying these rape videos are actually paying for a child to be raped.
Exactly.
The people
or even
who are
forwarding it.
In this particular case, silence is violence. In this particular case, if you are not reporting the rape of a child, you are guilty by omission, if not by commission. And in this particular case, the Supreme Court has made it very clear, the law is very clear that intent is immaterial. If you are failing to report, you will be jailed. You can be jailed, you will be jailed. And therefore, it is the duty and responsibility of everyone to come forward and report. At the same time, it is the duty and responsibility of the responding agencies to act in promptness and immediately with urgency. The financial institutions, the mental health professionals, the doctors, all the society needs to identify their own respective roles in responding to this situation. And as parents, as teachers, as media personnel, it is our duty to continue to make the people aware. People sitting in the villages have been made aware of the social media. They are aware of Instagrams and Facebooks and WhatsApps, and they understand that. If they understand that, they can also be made aware of this. The companies that are providing internet, companies like Airtel, companies like Jio, companies like Vodafone, all these companies should provide repeated messaging to their consumers that if you are searching for such a thing, using our internet connection, you can be identified and you can be jailed. The protection of children is the collective responsibility of the society. The role of the child is to be aware, and we have to make the child aware. But child is a responsibility of all of us, and therefore the rest of the society needs to come together.
Right, and conversely, how important does it become for the courts to gauge each case, and take a look at it and not interpret it narrowly, but also, given what the Supreme Court has said, so case by case basis?
It has to be seen within the perspective of organized crime, because cyber crime is now a part of the larger organized crime. When a person is raping a child, recording it and then circulating it, that person has actually made a business out of it. Not only is the rape by itself a crime, but you have monetized that rape and you are continuing to commit more and more and more crimes. The people who are searching for this material are therefore promoting that crime. That is an economic crime. Therefore, that is why it is important to identify the tentacles of that organized crime syndicate, identify each person who is a recipient of money. If people are creating these groups on telegrams and WhatsApps and circulating this, then not only are the people who are downloading or searching for criminally liable, but people who are a part of those groups, they are perpetuating it by not reporting. In fact, recently the CEO of Telegram has been arrested in France on these charges. The companies cannot be exonerated from this responsibility. The justice delivery system is one piece of the puzzle. The financial institutions is another piece of the puzzle. The prevention is another piece of the puzzle with the children, and the society at large needs to ensure that all these are held accountable and are made more responsive.
All right, and before we wrap, if you can tell us what we've already spoken quite at length about society, but what more can be done, and do we have a national, if we talk about the national database of sexual offenders, how does that work here in India?
Every single IP address that is seeking, downloading, collecting, circulating this CC material, every single person who is indulging in these WhatsApp groups, if they are identified, their names should be put on the national database of sex offenders. They should be barred and not allowed to work with the children in any capacity, in any school, in any hospital, in any childcare institution. People need to know and understand that what they are doing within the four walls and closed rooms is not a private act, it's a public crime, and somebody is watching. and the law will follow up.
Right, absolutely. So important. Thank you so much, Bhuvanji, for talking to us, taking us through this entire judgment and how each one of us needs to be aware. And clearly, it's something for society to act, for not just the police, not just the courts, but families and people. And I'd like to take that line that you said, silence is violence. So everyone must report this and, work to eradicate this evil from our society. Thank you so much for joining us. Thanks for watching. Goodbye.